And what Barr said is that this report, although Barr himself has made a conclusion that we've already known about, that he doesn't believe the president was guilty of obstruction of justice.
And John,
this report's, yes?
The report has been posted. The report has been posted publicly. So we're going to now try to go to the report itself. We're going to do this deliberately. We're going to take our time. We're going to make sure you all understand exactly what Robert Mueller wrote. And I want to begin with quotes, and I'm going to bring in our team on this from the Obstruction of Justice section. One of the things that Robert Mueller wrote is that several features of the conduct we investigated distinguish it from typical obstruction of justice cases. First of all, he said the investigation concerns the president's, and some of his actions, such as the firing of the FBI director, involves facially lawful acts within his Article II authority, which raises constitutional issues. But he also points out that the president, as the head of the executive branch, has unique and powerful means to influence official proceedings, subordinate officers, and potential witnesses, all of which is relevant to potential obstruction of justice analysis. And then a third point he brings out is that the evidence did not establish that the president was involved in an underlying crime related to Russian election interference. Although the obstruction statutes do not require proof of such a crime, he continues, the absence of the evidence affects the analysis of the president's intent and requires consideration of other possible motives for his conduct. Bottom line conclusion, though, also from Robert Mueller, and this is a direct quote from Robert Mueller: if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him. Dan Abrams, let's begin with the obstruction, your reading of these first excerpts that we're seeing.
So it seems that there's a lot of on the one hand, on the other hand, right? When you read through this, they're laying out certain reasons why there could be obstruction, and then other reasons why it wouldn't be obstruction. And then you go further on, and again, we haven't gotten to read the entire thing, but these are sort of the general conclusions here. And he then concludes with that statement that you just read. I think there's one other, there's another key phrase there with regard to obstruction of justice, and it's basically talking about it says, with respect to whether the president can be found to have obstructed justice by exercising his powers under Article II of the Constitution, we concluded that Congress has authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice. Under applicable Supreme Court precedent, the Constitution doesn't categorically and permanently immunize a president. But it sounds like what they're saying is that Congress hasn't done that yet, and that there's almost like a sentence missing that we still need to figure out in terms of, because that's a critical phrase there.
Okay.
So the question is, did the president obstruct justice? And that's a hard question to answer, not just because of the evidence. What did he do? Is firing Comey something he's constitutionally empowered to do in obstructing justice? But because it does raise these difficult legal issues. So they're sorting through both. I think the first thing I get from looking at it, from looking at the words of Robert Mueller and his prosecutors themselves, is that they looked at this question, not did this incident, firing Comey, amount to obstruction of justice? Did this incident, dangling a pardon, offer but a tapestry of conduct that they say, let's take a look at whether that tapestry is obstruction of justice?
Robert Mueller's exact words, because I think it's telling right here. I think you're right. He says there were two phases that they looked at dealing with obstruction. And the first phase, they write, covered the period from the president's first interactions with Comey, James Comey, the FBI director, through the president's firing of Comey. During that time, the president had been repeatedly told he was not personally under investigation. Soon after the firing of Comey and the appointment of the special counsel, however, the president became aware that his own conduct was being investigated in an obstruction of justice inquiry. At that point, the president engaged in a second phase of conduct involving public attacks on the investigation, non-public efforts to control it, and efforts in both public and private to encourage witnesses not to cooperate with the investigation. Judgments about the nature of the president's motives during each phase would be informed by the totality of the evidence. That second phase, when the president is under investigation, they lay out what he was doing.
Yeah, I mean, we're obviously going to need to see more detail, but one thing that it strikes me that this report seems to stand for the principle that the president actually isn't above the law, right? That seems to be in a lot of these excerpts that we're seeing. The obstruction of justice criminal statutes could apply to the president, that the president's conduct needs to be evaluated not just through the lens of these kind of constitutional powers that he has, but also that you know, in some ways protect him from being an ordinary criminal defendant, but also that he is given all these powers that mean we have to look sort of especially closely at the way he exercises that power. So this feels like the team of Mueller's team has come out with this sort of strong statement. The president actually can be scrutinized, not like any other criminal defendant, but is not beyond scrutiny. That seems really important.
There's an important phrase here about the Trump Tower meeting we've heard so much about. The June 9th, 2016 Trump Tower meeting. The report says that Trump had, quote, substantial involvement in the communications strategy over the Russia probe, but the evidence does not establish that the president intended to prevent Mueller or Congress from getting those emails to Don Jr. or other information related to the meeting.
Critical to obstruction. I want to bring in Chris Christie as well, former governor of New Jersey, now an ABC News contributor, also longtime friend of the president and a former prosecutor. Chris, your reading of this obstruction section.
Well, listen, I think that, again, a lot of stuff that's been discussed today, and the Attorney General talked about it, is about corrupt intent. And the statute does require corrupt intent. And I think that what they're really coming down to saying here, and what Mueller, again, I've just started to read the report as you have, but, you know, he was talking about what the president's motivations were, what was going on in terms of his knowledge of whether he was a target or not. I think all of that stuff is being laid out to discuss the issue of corrupt intent when you're trying to prove an obstruction case. It's a necessary element to an obstruction case, and I think that's what we're going to wind up seeing in the report is an examination of that as we go through the 10 instances.
And also the examination of obstruction case in a court of law and a possible determination by the Congress whether the pattern there is a high crime and misdemeanor. And Terry, that's what I want to take to you, because I want to pick up on those sentences that Dan read, and I'll read them again because I wonder if there might also be another interpretation of them. Under Article 2 of the Constitution, we concluded that Congress has the authority to prohibit a president's corrupt use of his authority in order to protect the integrity of the administration of justice. Under applicable Supreme Court precedent, the Constitution does not categorically and permanently immunize a president. Could that also be read to suggest that Congress could or should take a look at this?
Yes, so there's an argument going on. One argument, and it's the argument Bill Barr makes, which is that the president has plenary authority. He's got vast, sweeping authority over the execution of laws. So you can't really charge him unless Congress specifically says that you can't fire the FBI director or dangle a pardon. The pardon power is unbounded. And so calling the offer of a pardon, or the implied offer of a pardon, which we haven't seen yet, we should just fasten our seatbelts, we're going to learn a lot that we haven't heard yet, but calling that obstruction, Bill Barr would say, no, the president is the only executive authority, and therefore you can't do that. Mueller's team says, wait a minute, we can look at whether the president is subverting justice, even using the powers of the presidency.
And Congress can look at that.
And Congress can look at that. And so, while not a roadmap to any kind of impeachment, it is certainly an offer to Congress to take a look at this tapestry of things that we've heard about and things that we're about to learn about, private conversations that the Mueller prosecutors, the Mueller team felt, you know, that's fishy.
As we said, we've started to get the report. The public report has been released to the public. We're starting to read through it ourselves. Two big binders make up this report. One on the contacts and possible collusion, conspiracies between the Trump campaign and Russia. One on potential obstruction of justice by the president. We've just had an extended discussion about the obstruction of justice. I want to bring Pierre Thomas back in. Pierre, and let's read it, show a little bit more of what we have there, but also then let's turn to what we know about Mueller and what he found on the contacts between the Trump campaign and Russians. We'll start out just generally what you've been able to do over the last several minutes.
Okay, George, this is Volume 2, which deals with obstruction of justice. And one of the primary issues that Mueller contended with was the notion of intent. I'm going to read you something from the report. It says, quote, "The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if making traditional prosecutorial judgments." So the bottom line is that they had difficulty establishing his intent. And they did note in the report, however, George, that the president took a number of, quote, unseen activities to influence or control the investigation. So that was Mueller's primary concern, that there was a lot of activity by the president that was meant to influence and control the investigation, that much of it was done in plain sight, and he had difficulty establishing intent. The other thing, in looking at the Volume 1, which deals with the obstruction of justice, I was struck by a number of things. It lists many of the names that we've heard before: Carter Page, George Papadopoulos, people like that, Paul Manafort. But it also makes clear that the Attorney General of the United States, Jeff Sessions, was under active investigation, and they considered whether to charge him with perjury. The other significant thing is that they spent considerable time looking at the Trump Tower meeting in June of 2016. They clearly wanted to establish whether that involved a violation of the law. Some facts that influenced their decision: number one, after that meeting, there was apparently no follow-up. The Russians attempted to reach back out to the transition team involving the Trump campaign, but the Trump campaign did not respond. There are some details in terms of why, specifically, that the Mueller team decided that they could not bring any charges in relation to the Trump Tower meeting, because, George, as you recall, that was probably the most overt action taken by members of the Trump campaign to get negative information about Hillary Clinton from Russians. Here's what the special counsel had to say about that. Quote, campaign officials or individuals connected to the campaign willfully violating the law basically would be difficult to improve that they had the intent to violate the law. Quote, it says, bear with me here, George. On the facts here, the government would be unlikely to prove beyond a reasonable doubt that the June 9th meeting participants had general knowledge that their conduct was unlawful.
Right.
So basically,
that they knowingly and willfully violated the law. But there was an extensive section on that June 9th meeting. Of course, that was the meeting that Donald Trump Jr. had, where he had been told that they might be coming with emails related to Hillary Clinton. The other names, one of the names you didn't mention, they say that Jared Kushner, Paul Manafort, Eric Prince also had contacts as well. But Pierre, take a step back, because you've had a chance to spend a little bit more time with this than we have. One of the things we heard from the Attorney General William Barr is that this was likely, this was lightly redacted. We now know the report is about 448 pages. From your first reading through, could you tell how extensive these redactions were, and which one of those four categories, whether it was grand jury material, intelligence material, material affecting ongoing investigations, or material affecting individuals' privacy, do you have a sense generally of what kind of redactions we're seeing here?
Right. Many of the redactions I saw were related to grand jury. But, George, I have to tell you, there's not a lot of redactions in here. There's page after page after page where you're simply reading the material. There are some words redacted here and there, but again, it's page after page after page, at least on the obstruction of justice section, volume 2, where it is not redacted, George.
So and that's a key point there, because on the obstruction of justice section, Kate Shaw, almost all the information, if not all the information that the special counsel developed on obstruction of justice was through interviews, not through a grand jury. Right.
And it seems like some of the evidence just came from public statements, right, which wouldn't have required any sort of sophisticated investigation techniques at all. So I'm too struck by the minimal redactions in parts of this report. There's very little that seems to be predicated on this personal privacy of third parties that we heard Attorney General Barr talk about. That struck me as the weakest legal basis on which to withhold when this report is in litigation. So I think that the Department of Justice has made the correct and cautious call not to overuse that basis for redaction. There is a good deal on ongoing matters. You know, we're all trying to figure out what.
Including the discussion of WikiLeaks, because, of course, Roger Stone, who is reputed to be in contact with WikiLeaks, that he's facing trial.
That's ongoing, right. So quite a big, sort of a few pages of fully redacted text in that section. But otherwise, I don't think we knew whether of these 400-plus pages we were going to have, 100 pages of text or several hundred. And right now it does look like the redactions have not been excessive.
And John Carl, though, the clearest area so far of disagreement, and again, we're just beginning to read through this report, and we are going to take our time with this, and we're going to make sure we get it right. But I want to put up on the screen one more time. There's one clear disagreement between William Barr and Robert Mueller, and this is that sentence where Robert Mueller wrote, "If we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him." William Barr said he did not obstruct justice. Robert Mueller said we couldn't reach that judgment.
Absolutely, and in fact, George, Robert Mueller outlines here reasons, and we're still going through this, but reasons that there are significant concerns about the president's actions that would suggest possible obstruction of justice. So he is emphatic. He could not clear the president of this. He did not exonerate the president on the question of obstruction of justice. In fact, he found chapter and verse cases that raise serious concerns and questions about whether or not the president, in fact, obstructed justice.
And Mary Bruce, our senior congressional correspondent, Congress, as we said, now does have this report along with the rest of the public. I'm sorry, she's actually in the president's event right now. Terry Moran.
So as we go through it, we are confronted with, first, a lot of new information. The first thing to say is there is a lot of stuff that the public has not heard. Private meetings, comments by the president, and that in part goes to Attorney General Barr's notion that the president cooperated. He could have claimed executive privilege. He let his lawyer, his White House lawyer, spend hours with the special counsel. He didn't claim executive privilege. They turned over 1 million documents. So we're going to learn a lot, and some of it isn't pretty.
And one thing we talked about is Don McGahn, right? We've been talking about the former White House counsel, and what will he say? And this is page 113. The president orders McGahn to deny that the president tried to fire the special counsel. And then they give the background on what happened. In late January of 2018, the media reported that in June 2017, the president had ordered McGahn to have the special counsel fired based on reported conflicts of interest. McGahn had refused, saying he would quit instead. After the story broke, the president, I'm reading directly from the report, the president, through his personal counsel and 2 aides, sought to have McGahn deny that he had been directed to remove the special counsel. Each time he was approached, McGahn responded he would not refute the press accounts because they were accurate in reporting on the president's efforts to have the special counsel removed. The president later personally met with McGahn in the Oval Office with only the chief of staff present and tried to get McGahn to say that the president never ordered him to fire the special counsel. McGahn refused and insisted his memory of the president's direction to remove the special counsel was accurate. That's pretty damning stuff, just in terms of, again,
and what is the date on that again?
That's late January 2018.
So in shorthand, the president ordered his lawyer to fire the man investigating him, and then ordered his lawyer to say he didn't give that order. Now, if you're a prosecutor, that's something to look at, for sure.
Something to look at if you're a citizen.
If you're a citizen as well, that's where we are. Exactly. We are in the area where every single American has the right to look at this and make up their own minds about the president's conduct.
And of course, to see this was after some of the comments from the president, but the president consistently, when asked in the past and throughout 2017 about firing Robert Mueller, said, no, I'm not thinking about it at all.
Yes, but it was also sort of hard to gauge because he sort of seemed to waffle back and forth. There were days when he was furious with him, and then there were days where he seemed to say, like many and most in Washington did, that he was a reputable character. But you know, I mean, as we got closer to the release of the report last month, the president's attacks on Mueller became increasingly personal and, frankly, increasingly nasty. And they went directly after him. There was a long time where he never even named Robert Mueller in his Twitter account, and then just went full bore at him.
Mm-hmm. And even though after William Barr's summary, the president did say that Robert Mueller was an honorable man, and then continued the attacks in the days after.
And here's another overview, page 107. From the summer of 2017 through 2018, the president attempted to have the Attorney General Sessions reverse his recusal, take control of the special counsel's investigation, and order an investigation of Hillary Clinton. So you have another And again, that's not something that comes as a surprise, but it's something that was reported. And the question was, what do we know? How much do we know about it? And we now have the special counsel drawing that conclusion as well.
That was fake news, according to the President of the United States. It's now in the special counsel's report.
And those are two different things we're going to be looking at all day long as we go through this report. There was, as you said, Dan, a fair amount that already was in the public record. What does Robert Mueller ratify about what was already in the public record? And then what new facts did he uncover as we go along here? But Keisha, on the obstruction question, so much of this is going to be an interpretation of the law and Congress's responsibilities.
Right. So obstruction of justice was central to the impeachment, or the impeachment that never went forward, of President Richard Nixon, of President Bill Clinton. Obviously, obstruction was one of the charges that the House approved. So that has been central to previous episodes involving presidential misconduct. And, here we seem to have a prosecutor, a special counsel, concluding that there's a lot of evidence that seems to amount to something that looks like obstruction of justice. Does the conversation on the Hill change in that so far Speaker Pelosi has been pretty emphatic that impeachment isn't on the table? And I don't know. I think a lot will turn on the public's reaction to this, right? So the conduct that we're reading about has, implications in terms of its potential criminality, but also in terms of potential congressional responses. And I think that's connected to sort of how the public feels about the depiction of conduct that they're going to read about today.
And much of that will depend on what facts seep through to the public, which ones they seize on. Right. John Carl, you're also working on this one. We've been talking about Don McGahn, the former White House counsel, who we know spent multiple hours, at least 30 hours, probably more, with the special counsel, and he is clearly a central player in this report.
Absolutely. As mentioned, we see that the president directed McGahn to tell Sessions not to recuse himself and then to undo the recusal once he had. But if you look at this very interesting point where Don McGahn was directed by the president to do something that he felt would have been clearly obstructing justice, and refused. This is in the volume on obstruction of justice. On June 17, 2017, the president called McGahn at home and directed him to call the acting attorney general, and say that the special counsel had conflicts of interest and must be removed. McGahn did not carry out the direction, however, deciding he would rather resign than trigger what he regarded as a potential Saturday night massacre. And then, George, it goes on to describe the president's actions to try to enlist one of his prominent outside advisors to get involved in this effort. Corey Lewandowski, who for a time was, of course, the president's campaign manager, had a one-on-one meeting, according to this report, on June 19, 2017, in the Oval Office. And the president dictated a message for Lewandowski to deliver to Jeff Sessions, the Attorney General. The message said that Sessions should publicly announce that, notwithstanding his recusal from the Russia investigation, the investigation was very unfair to the president, and the president had done nothing wrong, and that Sessions planned to meet with the special counsel and, quote, let him move forward with the investigation into election meddling for future elections. Lewandowski was to deliver this message to Sessions. And he met with him, met again with the president the next day. The message had not been delivered. And according to this must come from Lewandowski's discussions with the special counsel. Lewandowski did not want to deliver the president's message personally. So he asked another White House official to do so. So you have cases here where officials in the White House, Don McGahn, outside advisor Corey Lewandowski, are being directed to take steps to essentially interfere with the investigation and are refusing to follow the president's orders.
So we know that the president, at times, he did remove James Comey. At times, he wanted to remove Robert Mueller and was complaining about his own Attorney General, Jeff Sessions. Chair Moran.
And this is something new, another act that the prosecutors thought might be part of that tapestry that would amount to obstruction of justice. That the president, in March of 2017, met with the Director of National Intelligence, Dan Coats. This is on page 55 for those reading along at home. The president asked intelligence community leaders to make public statements that he had no connection to Russia. Coats says that the president never asked him to speak to Comey at all. But two named officials, who are Dan Coates, the Director of National Intelligence, top aides, say that when he came back to his office, he said the president had said, is there a way that the intelligence community to get the investigation, get it over with, end it, or words to that effect. So this is the president now reaching out, according to the testimony of Michael Dempsey and Edward Gestaro, the president reaching out to the intelligence community saying, can you interfere with the FBI? That's what Nixon was impeached on in part, which was he was on tape saying, tell the CIA to tell the FBI to stop investigating Watergate because it'll get into national security meetings, issues. And here, at least on page 55, is the suggestion, not from Coates himself, but from Coates' two aides who said when he came back after meeting with the president, he said, the president wanted me to get involved in this FBI thing and there's no way I'm going to do it.
No way he's going to do it. Let's take a step back on the obstruction because we now have the executive summary of the obstruction section as well, and it does lay out pretty clearly the 10 areas they looked at for obstruction that included the campaign's response to reports about Russian support for Trump. That, of course, deals with the president's response to WikiLeaks and the hacking, and it also points out, Cecilia Vega, that even though as late as 2016, the Trump organization had been pursuing a licensing deal for a skyscraper, that Trump Tower in Moscow. The president continued to deny any links or any contact.
And we've known about that going in, and that's something that he's maintained all along. I'm also now reading, George, through some of the president's answers, presumably written in coordination with, if not by, his legal team to the direct questions that Robert Mueller and the investigators posed to him. And they're going through all of these point by point, talking even in great detail about, you'll remember that speech from the campaign trail when the president says, hey, WikiLeaks, if you're listening, which became a huge, a monumental, we didn't know at the time, a monumental phrase that we've now gone back to over and over. And he's saying, I have, that was made in jest, that I was joking, and that anybody who was watching me would have known. So as we pour through this, we're going to learn more and more about some of the intricacies and the inner workings of things like the Trump Tower meeting and the Moscow deal.
And one of the other things, Dan Abrams, that is explained here in the report is why Robert Mueller chose not to push that issue of actually interviewing the president and accepting those written responses.
That's right. And, you know, the question was, is he going to be relying on a sort of technical Department of Justice guidelines issue, which is what targeted the investigation? That's not what I'm seeing here. What I'm seeing is actually just the amount of time it would take and the delay that
and he thought he could get what he needed. Yes,
exactly, from other witnesses and other people. So he, in the end, didn't feel that it was necessary and worth, in effect, the amount of fighting that would have had to ensue and time it would have taken to get the president to answer those questions. I am seeing something additional here about the president's answers or lack thereof on certain questions about Michael Cohen.
Right.
It says on September 17, 2018, this office submitted written questions to the president that included questions about the Trump Tower Moscow project and attached Cohen's written statement to Congress and the letter of intent signed by the president. Among other issues, the questions asked the president to describe the timing and substance of discussions he had with Cohen about the project, whether they discussed a potential trip to Russia, and whether the president at any time directed or suggested that discussions about the Trump Tower project should cease, or whether the president was informed at any time that the project had been abandoned. On November 20, 2018, the president submitted written responses that did not answer those questions about Trump Tower Moscow directly and did not provide any information about the timing of the candidate's discussions with Cohen about the project or whether he participated in any discussions about the project being abandoned or no longer pursued. Instead, the president answers stated in relevant part, quote, I had few conversations with Mr. Cohen on the subject. As I recall, they were brief and they were not memorable. I was not enthused about the proposal, and I do not recall any discussion of travel to Russia in connection with it. I do not remember discussing it with anyone else at the Trump Organization, although it is possible. I do not recall being aware at the time of any communication between Mr. Cohen and Felix Sater and any Russian government official concerning the letter.
And, of course, those words, I do not recall, are always the words that lawyers would have you use in discussions.
And the fact that the special counsel is saying he's not answering our questions. Yeah. I mean, that's not my characterization. That's the characterization from the special counsel.
To me, that just really raises the question why they didn't push harder to interview him, right? So they could have tried to nail some of this down, I think, by actually having an in-person interview rather than relying on written responses, some of which are non-responsive. you know, and maybe the open question that might be presented if they are they'd have to maybe litigate it if the president didn't want to sit for the interview and they didn't want to go to a Supreme Court and have this drawn out divisive fight about the president's ability to be, you know, compelled to testify against his wishes. And then if somehow they did get testimony from him, there's the possibility of perjury, right, which opens up a whole new front of kind of questions regarding the president's, you know, ability to be indicted for criminal conduct.
Which is, of course, what got Bill Clinton in trouble as well. Pierre Thomas?
Go ahead, George. I couldn't quite hear you.
No, you're weighing in now on the president's answers that we were just hearing. Kate Shaw, go ahead.
That's right. So the president was asked specifically about what he knew about the Trump Tower encounter with Don Jr., Paul Manafort, and Jared Kushner. And we're now seeing his responses for the first time. He says, quote, "I have no recollection of learning at the time that Donald Trump Jr., Paul Manafort, or Jared Kushner was considering participating in a meeting in June 6, 2016 concerning potentially negative information about Hillary Clinton. Nor do I recall during the campaign that in June of 2016 that the meeting had taken place, that the referenced emails existed, or that Donald Trump Jr. had other communications." So he's basically saying he did not know about it. That's what he's telling the special counsel. And then he also says, "I have no independent recollection of what portion of these 4 days in June 2016 I spent in Trump Tower." So he's saying that he has a very foggy memory in regard to that. And George, there's also some pretty interesting color that we found here about how the president first reacted when he was told that there was a special counsel investigation. He was apparently told by Jeff Sessions, and his quote was to the effect of, "Oh my God. This is terrible. This is the end of my presidency." That's according to one of the aides, George.
Yeah, that and also included something we cannot say right now on TV. I want to bring John Carl in for more.
I excluded that.
John Carl, for more on that right now. John, again, we have known from what the president has said in public, from the president's tweets, how angry he was about this. But we're seeing much more feeling now from inside the Oval Office, based in part on that extensive cooperation from the president's aides.
And what is significant about this is we learned that the president was in the Oval Office talking about potential candidates to replace James Comey as the FBI director. He was meeting with Jeff Sessions, the Attorney General, Sessions' Chief of Staff, Jody Hunt, and Don McGahn, the president's counsel, when Sessions got the phone call from Rosenstein saying that he had made the decision to appoint the special counsel. So it's when Sessions comes back into that meeting that the president has the reaction that you just heard from Pierre. This is the end of my presidency. And he goes on to say, this is the worst thing that ever happened to me. And during that meeting, he begins to tear into Jeff Sessions, the Attorney General, saying, "How could you let this happen, Jeff? How could you let this happen?" And he contrasts him to Eric Holder and to Robert Kennedy, who the president is saying, "You were supposed to protect me." The president is telling his attorney general, quote, "You were supposed to protect me." So very interesting insight into the president's state of mind in those first minutes after learning that there was a special counsel.
George, here are a couple of critical paragraphs with regard to obstruction. One, this is page 157, that helps the president a little bit and understands why Barr made the comment he did in the press conference. It says, "In this investigation, the evidence does not establish that the president was involved in an underlying crime related to Russian election interference. But the evidence does point to a range of other possible personal motives animating the president's conduct. These include concerns that continued investigation would call into question the legitimacy of his election and potential uncertainty about whether certain events such as advance notice of WikiLeaks release of hacked information or the June 9, 2016 meeting between senior campaign officials and Russians could be seen as criminal activity by the president, his campaign, or his family." On the other side of this, and this is, I think, one of the most interesting paragraphs in here so far, the president's efforts to influence the investigation were mostly unsuccessful, but that's largely because the persons who surrounded the president declined to carry out orders or accede to his requests. Comey did not end the investigation of Flynn, which ultimately resulted in Flynn's prosecution and conviction for lying to the FBI. McGahn did not tell the acting attorney general the special counsel must be removed, but was instead prepared to resign over the president's order. Lewandowski and Dearborn did not deliver the president's message to Sessions that he should confine the Russia investigation to future election meddling only. And McGahn refused to recede from his recollections about events surrounding the president's direction to have the special counsel removed, despite the president's multiple demands that he do so. Consistent with that pattern, the evidence we obtained would not support potential obstruction charges against the president's aides and associates beyond those already filed. So, in essence, what we're hearing the special counsel is saying is, boy, he was trying really, really hard, but the people around him weren't letting it happen.
And then the question is, what does Congress do with information like that, where they could look at that and say, listen, if the president's orders would have been carried out, that might have been a crime. Does it demonstrate an abuse of power? Does it demonstrate unfit for office, even if it doesn't reach that illegal bar?
And there is this line, this key line from the Mueller report. With respect to whether the president can be found to have obstructed justice, we concluded that Congress has the authority to prohibit a president's corrupt use of his authority to protect the integrity of the administration of justice. Now, they can do that by passing a law saying the president can't do X, Y, or Z, or they can do that after the fact by saying this pattern, and we're just beginning to learn about it, while it may not have risen to the level of a criminal charge of obstruction of justice, is clearly an effort by the person sworn to uphold the laws of the land to try to get people to help him subvert them. And if they decide that, then we're off to the races.
Chris Christie, one of the remarkable things here is how much we're learning from the president's aides.
Oh, it's absolutely right. And I think what you've seen here is that the decision, the early decision by the president and his legal team to not claim any privilege and to allow everybody who the special counsel wanted to speak to, absent the president, to go and speak to the special counsel, that these people, it appears, were, from what we can tell from the early reading report, very candid, very direct about their interactions with the president, and that there was no attempt by these folks, at least as far as I could tell in the early reading of the report, to sugarcoat this stuff in any way.
Yeah, but to pick up on what Dan Abrams was reading there, though, they clearly were candid, as you say. That portrait of the president's aides not carrying out his wishes in a way that might end up protecting him from an obstruction of justice charge, pretty remarkable.
Well, it is, although I will tell you this, too, though, George. I think having been a chief executive in a state, that's part of what you count on your aides and the people around you to give you advice and to help you with. There are times when you're a chief executive, you're going to get emotional about certain things and say things, and your aides are going to come to you and say, listen, we can't do this, or you can't say that. I'm not saying that ever really involves criminal conduct, as we see, potential criminal conduct, as we see here. But I think what chief executives count on their aides to do is to be, an informing effect, a moderating effect. And I think that one of the things that is good to see in this report is the fact that all these people stood up to things that they thought would be questionable conduct and refused to do it. I think it says a lot for guys like Don McGahn in particular, who seemed to stand up to some particular pressure that came to him, and he didn't give in.
And John Carl, you're picking up more from inside the White House in the report?
I am. This is a section of the report, again, on the question of possible obstruction of justice. Recall that Rod Rosenstein was the person responsible for overseeing the special counsel investigation because of the Sessions recusal. And we have here a suggestion that there was a consideration to firing Rosenstein. Let me read to you this. Keep in mind the number 3 official at the Department of Justice at this time is somebody named Rachel Brand. So here we go. In early July 2017, the president asked Staff Secretary Rob Porter what he thought of Associate Attorney General Rachel Brand. Porter recalled that the president asked him if Brand was good, tough, and, quote, on the team. The president also asked if Porter thought Brand was interested in being responsible for the special counsel's investigation and whether she would like to be Attorney General one day. Because Porter knew Brand, the president asked him to sound her out about taking responsibility for the investigation and for being Attorney General. Contemporaneous notes taken by Porter show the president told Porter to keep in touch with your friend, a reference to Brand. Later, the president asked Porter a few times in passing whether or not he had spoken to Brand, but Porter did not reach out to her because he was uncomfortable with the task. In asking him to reach out to Brand, Porter understood the president to want to find someone to end the Russia investigation or fire the special counsel, although the president never said so explicitly. Porter did not contact Brand because he was sensitive to the implications of that action and did not want to be involved in a chain of events associated with an effort to end the investigation or fire the special counsel. So once again, a pretty glaring effort of the president asking a subordinate to do something that the subordinate feels would be either unethical or illegal. Rob Porter was the staff secretary. He was a friend of Rachel Brand over at the Department of Justice, and he refused to go and to deliver that message to Rachel Brand. And of course, in the end, Rosenstein's never fired. Rachel Brand is never put in charge of the investigation, and presumably not until now knew about this chain of events.
Yeah, well, go ahead, John.
One other thing in this section, which keeps coming up, is, again, Rod Rosenstein is in charge of the special counsel investigation because the Attorney General has recused himself. And as we know, the president was furious about that decision. Here's something interesting from the testimony of Hope Hicks, another one of the president's close advisors, who freely met with the special counsel. Hicks said that the president viewed Sessions' recusal from the Russia investigation as an act of disloyalty. In addition to criticizing Sessions' recusal, the president had raised other concerns about Sessions and his job performance with McGahn and with Hope Hicks.
So one of the things clearly established by Robert Mueller so far, and we're just working our way through this 448-page report, is that on several occasions the president directed staff, encouraged staff to remove every single person in charge of the investigation at various times, whether it was the Attorney General, whether it was the special counsel, whether it was James Comey, the FBI director. I do want to take a step back right now and reset. Of course, the report was made public about 45 minutes ago, as we've said, 448 pages. It's divided into two main sections, looking at whether they could establish collusion with Russia, conspiracy with Russia, also obstruction of justice. As we've said, the special counsel themselves did not draw any ultimate conclusions over the president's conduct on obstruction, though he clearly states that he could not exonerate the president. There's that quote right there. If we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. We also know that the Attorney General was investigated for potential perjury and that the president directed White House counsel Don McGahn to fire Robert Mueller. One of the other points he makes, and I want to go back, this goes back to the Michael Cohen section on obstruction of justice, and it's a pattern that Robert Mueller established, is that the president discussed pardons with the president's personal counsel and believed that if he stayed on message, he would be taken care of. But after Cohen began cooperating with the government in the summer of 2018, the president publicly criticized him, called him a rat, and suggested that his family members had committed crimes. This is something we saw often. We saw it with Paul Manafort. We saw it with Roger Stone. We saw it with Michael Cohen. The president thought witnesses were on his side. He praised them publicly. When he thought they were going in the other direction, he criticized them. And Robert Mueller is now citing this as well.
And honing in on that, which goes back to, I think, I would assume his confliction, self-confliction as to whether he could cite obstruction of justice for this against this president. I'm also still pouring through, George. I want to bring up to you the response from the president, and I apologize to our team because I'm not able to get the actual page here, but this is from the president. I'm just struck by the number of times that he and his team say that they do not recall in his written answers. They do not recall everything from talking about WikiLeaks. They do not recall everything from talking about things that we mentioned about Michael Cohen, about the Moscow Trump Tower deal. But this section in particular about Roger Stone, and I'm on the C addendum, I think, page 13.
This is all in the appendix.
All in the appendix, yeah, thank you. I spoke by telephone with Roger Stone from time to time during the campaign. I have no recollection of the specifics of any conversations I had with Mr. Stone between June 1st, 2016 and November 8th, 2016. that stretch of time? You can't remember one specific thing? I mean, you kind of scratch your head at that. I do not recall discussing WikiLeaks with him, nor do I recall being aware of Mr. Stone having discussed WikiLeaks with individuals associated with my campaign.
And a lot of that section also is redacted because some of that is grand jury material or is facing the continuing investigation of Roger Stone.
There's a portrait that's emerging of Donald Trump during these months from these pages. This is a man in a fight, and he is fighting like a beast. At the same time, he's won an election he probably didn't expect to win, and trying to do the hardest job in the world. And so you can look at this evidence of telling people, get this investigation away from me in two ways, and the country will. On the one hand, he's trying to subvert a legitimate investigation into an attack on our country by Russia and whether or not he or anyone around him participated, and he's trying to subvert that. The other way you can look at it is he's got the biggest job in the world to do. He is furious. He sees this as a political fight for his life, for his political life and maybe for his freedom, and he cannot believe that the people who work for him won't help him stop it so he can get on with what he was elected to do, the business of the country. That's the way this reported. That's the portrait that's emerging, a man fighting with fury, asking everybody around him, will no one rid me of this meddlesome investigation? And the question is motive.
Right. Well, but does the motive there really matter of whether he's protecting? I mean, in both cases, he still ends up protecting himself.
Well, but he has the right to discharge the duties of the president's office. And he took an oath to do it. And his lawyer at one point said the president can't obstruct himself. He is the administrator of justice. We have one president, right? And so the question is he trying to essentially say, guys, go look at some real crimes so I can get on with this business that I was elected to do? Or is he saying, I cannot let this investigation get any closer to me because they're going to catch me? And that's the question.
And I think, again, taking a step back as well, it does seem clear that on the issue of obstruction of justice, it was not inaccurate for the Attorney General Barr to say what he said in his letter about Mueller simply not being able to reach a conclusion. That has been borne out by what we see in the report.
Not being able to reach a conclusion that he did obstruct justice.
Correct.
He also says he could not reach a conclusion that he did not obstruct justice.
But that was that was in the letter that Barr provided as well. And, you know, the question that I had going into this was, how much is Mueller going to rely on, for example, Office of Legal Counsel, guidance on not indicting a sitting president? And it seems that it was really more simply based on his analysis of the law and the facts and how difficult obstruction can be, A, when you're the president, B, when you don't have an underlying crime, C, saying, look, I'm not saying that public acts can't be obstruction, but all of this together does not make for an easy obstruction case. Right. And I think that's an important sort of step back as to, you know, what these hundreds of pages of documents are saying about that issue.
And presumably, if and when Robert Mueller is called to the Congress, he'll be asked the direct question, what did you intend? Did you intend for this to come to us or not? And we'll hear that answer from him personally. John Carl, I know you've been combing through the report and you've come up with something else you want to highlight?
Yeah, 2 points. One is my count so far, and again, we're still working our way through this, but I count 5 people close to the president who refused to follow the president's directives on issues that would have raised obstruction of justice concerns. And the list is pretty incredible here, George. First of all, obviously, Jeff Sessions refusing repeatedly to undo his recusal, and Mueller points out the reason why he wanted that was so that Sessions could constrict the investigation. Don McGahn, his White House counsel, repeatedly refusing to do things like fire the special counsel. Corey Lewandowski, as I described earlier, his former campaign manager, one of his most intensely loyal outside advisors, refusing to pass a message along from the president to the attorney general because he was concerned about the appropriateness of that message. Rob Porter, who interacted with the president as much as anybody in the White House before he was eventually fired, the White House staff secretary, refusing to pass a message to Rachel Brand. Rick Dearborn, one of the deputy chiefs of staff, also listed here as refusing to carry a message to Jeff Sessions. So here you have the people that are with the president, that are closest to the president, that are the most loyal to the president, refusing to carry out his directives because they felt, presumably, that these would be illegal. Really an extraordinary tapestry here looking at this. They may have protected the president from himself. If they had gone through with any of these, the implication here is that there would be an obstruction of justice case. Now, George, one other thing is the question of the president's memory in those written questions. Mueller makes it very clear here that he wanted to interview the president in person. He writes, this is on Appendix C. The written responses, we informed counsel, demonstrate the inadequacy of the written format, as we have had no opportunity to ask follow-up questions that would ensure complete answers and potentially refresh your client's recollection or clarify the extent or nature of his lack of recollection. Then he writes, Mueller writes, we again requested an in-person interview limited to certain topics, advising the president's counsel that this is the president's opportunity to voluntarily provide us with information for us to evaluate in the context of the evidence we have gathered. Mueller says that he then, when he didn't get a yes answer, they considered whether or not to issue a subpoena for the testimony. And the reason, prominent reason, that Mueller did not go forward with a subpoena is that it would have dragged out the investigation.
It would still be in the
so
courts
it's very
today.
clear that the president, that Mueller wanted to talk to the president. The president had said publicly that he was willing to talk to Mueller under oath, but he steadfastly refused repeated efforts by the special counsel to interview him in person.
And that may have helped him. I want to bring in Tom Bossert, also as the former director of Homeland Security inside the White House for President Trump. And I want to pick up on the previous point that John was making, that pattern of the president saying he wants actions from his subordinates to stifle the investigation. Those individuals inside the White House refusing. I mean, you worked inside the White House. You worked closely with President Trump. Does it ring true to you?
Well, I mean, I guess it rings true to me that this president, I think it's no surprise, is pretty on his sleeve with his emotions. When he was angry, we knew it. When he was happy, we knew it. And when he wanted something done, he expressed it to us. But I guess what's not being said here is that he was also, whether it was in a grouchy or begrudging way or otherwise, willing to receive that advice that Governor Christie spoke of. So it wasn't always welcome when we pushed back and informed him that something wasn't legal or proper or effectable. He did it. You know, he said it and he asked us to do it. And then when he took advice back, he grumbled. But I think what we're seeing here today is the president was really well advised by a lot of people that probably deeply frustrated him. And he might not have been well advised by some people that were on his campaign in the beginning, and he just didn't know it at the time. So this is fascinating to read through. George, I have another observation here as I go through this with all the rest of us today. I'm struck that Director Comey kind of got us into this mess. I mean, the Russians got us into this mess, but Director Comey kind of started some of this for us by making a prosecutorial decision when it wasn't his role to do so with the Hillary Clinton emails matter. And now we have a special prosecutor who's given the express authority to prosecute crimes in his mandate from the Deputy Attorney General, who chooses, and it's pretty clear, he doesn't say why, but he says, we've chosen not to make a traditional prosecutorial decision here. I mean, the big question for me is why? You can't say because it was hard. There are theories as to why Director Comey made that decision at the time, and he's written about it in his book, so you can debate. But why would this special prosecutor choose to really take a pass on his
well, one of the big differences is, of course, Tom, thank you, is that, of course, that James Comey was not looking at the President of the United States then. He was looking at Hillary Clinton, and here the President of the United States was the subject. And Kate Shaw, you've found another portion of the report directly on that point.
So in Volume 2 on page 1, we actually do get to see what the special counsel made of this OLC position, that a sitting president can't be indicted. honestly, it's a little confusing what it is they're saying. But basically they say, we are part of the Department of Justice. We've accepted the Department of Justice's view that a sitting president can't be indicted. That said, there's nothing to prevent a sitting president from being criminally investigated. In fact, OLC has actually said that's okay. So we're doing an investigation. But we also determined not to apply an approach that could potentially result in a judgment that the president committed crimes. So they've decided from the jump that they can't conclude that he committed a crime, and yet they do this thorough factual investigation and don't rule out the possibility that he did.
Can you read that
it's a confusing sentence.
Yeah,
Page 2 of Volume 2. Page 2 of Volume 2, which is the obstruction of justice portion. We considered whether to evaluate the conduct we investigated. This is the first full paragraph. Under the Justice Manual standards governing prosecution and declination decisions, but we determined not to apply an approach that could potentially result in a judgment that the president committed crimes. So we essentially decided before we started the investigation what we couldn't conclude.
Yeah, but we determined it there, but he actually doesn't say why they made that determination.
Well, then he goes on a little bit, and he says, here's a couple of things. One, fairness concerns counsel against potentially reaching that judgment when no charges can be brought, in part because if they say he committed a crime, but they can't charge him for it, he can't defend himself the way he could in court. Now, I think that misses the fact that the president has this bully pulpit he can use to defend himself, but that at least is the judgment that it seems that this very experienced team of prosecutors made, that so he can't be indicted, he can be investigated, but there's kind of these constraints on the investigation, which is that there's one conclusion: they don't believe they have the legal authority to reach. Now, tell me if you guys disagree with how I'm reading this, but I think that's what it says.
And he's basically saying that they're applying 4 factors, right, in terms of evaluating the possibility of obstruction of justice. And the fact that, 1.5 of them relate to the Office of Legal Counsel's view on a sitting president not being indicted, it is clear that was a factor in the way that they looked at the evidence here. Because it does say, second of the 4, we first described the considerations that guided our obstruction of justice investigation, and then provide an overview of this volume. And then number 2 is, while the OLC opinion concludes that a sitting president may not be prosecuted, it recognizes that a criminal investigation during the president's term is permissible. The OLC opinion also recognizes that a president does not have immunity after he leaves office. And if individuals other than the president committed an obstruction offense, that may be prosecuted at this time. Given those considerations, the facts known to us, and the strong public interest in safeguarding the integrity of the criminal justice system, we conducted a thorough factual investigation in order to preserve the evidence when memories were fresh and documentary materials were available. So basically they're saying, yes, the OLC says a sitting president can't be indicted, but that doesn't mean that we can't pursue this investigation.
Right, but and this is what's also significant here, and we're just going through this right now, is that was a significant part, Terry Moran, of Robert Mueller's judgment right there. But in fact, William Barr said that he disregarded that.
Right. He stepped right in and said there's no obstruction of justice crime here. Regardless of what he said. Well, this is a punt. I'm with Tom Bossert. You got hired essentially to make these decisions. You're the prosecutor. I'm not quite sure why. And reading between the lines, it looks like there was a disagreement on the team. There were some gung-ho prosecutors who thought they could move forward in this, and some who couldn't. And the solution was found in Watergate. Okay, so Watergate was the investigation of a president for obstruction of justice. Before the grand jury, the prosecutors in Watergate had presented it, and the grand jury named Nixon as an unindicted co-conspirator. So they got him in the conspiracy, but they didn't indict. Now that was secret, but it leaked months later. And there's a reference here. We didn't want to go that route because it would leak.
But hasn't the, and correct me if I'm wrong about this, but didn't this OLC interpretation of the law come out in the wake of Watergate?
Yes, and then it was reinforced during the Clinton investigations, where the sitting president, and this is a debate that's gone back to the beginning of the presidency, can't be indicted because you would disrupt the functions of the government too excessively. But you could